Welcome to one and all. Today I am presenting the topic Environment and Access to Justice. I am Dr. G. Shabir Ali, Head of the Department, LLM and Research Coordinator, VM Salgaonkar College of Law, Goa. Today the structure of presentation is as follows: learning objectives, introduction, protection of environment during British period, ancient period, and after independence, role of the state in environmental matters, evolution of new doctrines, access to justice under special enactments dealing with environment and concern. Learning objectives. The module is designed to understand the protection available to environment during ancient times, learning various remedies available in case of environmental pollution in Indian scenario, to comprehend various rights available to community against environmental pollution and access to justice, to verify various remedies available under special enactments to deal with environmental pollution. Protection of environment gained momentum only after the first global conference in the year 1972 at Stockholm Conference. Protection of nature is important for our survival. If we destroy nature, nature destroys us. Protection, conservation and preservation of environment is a duty of each and every person in our society and in our country. Natural resources like water, air, sky belongs to each and every one of us or to the entire community. Pollution of environment results in damage to the whole community. Due to development of industrialization, science and technology result into various problems like global warming, acid rain, ozone depletion. One of the most important problem is environmental pollution. Protection of nature received global attention only after Stockholm Conference. Environmental development during ancient times. Generally, environment means our surroundings. Environment consists of two important components, biotic and abiotic components. Biotic means living, abiotic means non-living. There are always interaction between living as well as non-living components. Change in one component results in change in other component. For example, if the population growth increases, definitely there are problems with respect to water, air and land. Protection of environment is not a new phenomenon in India. In India, this idea can be traced back to ancient times. All our ancient scriptures mention about protection of environment. Vedas, Puranas, Bible, Quran, all these ancient scriptures mentions about important and need for environmental protection. Jainism and Sikhism also mention about tolerance towards living things. Worshipping of animals and plants shows the respect given to the environment during ancient times. Water is treated as a purifier in the ancient time, and when a person about to die, they are giving Ganga Jal, thinking that it may purify or the person may relieve from all kinds of diseases. Even today, people take the blessings of Mother Earth before they are entering into any cricket field or a hockey field or entering into any play. All this shows concern for environment and protection for environment. We believe that God is the creator of this universe. Once we believe that God is the creator of the universe, we are not there to destroy God's creation. State as a protector of environment. Once the concept state evolved, state became the protector of environment. State consists of various communities. State is empowered to issue licenses, permission or consent to start any industry, project, plan or construction. No one can start any activity without the permission or consent of the state. Before giving consent, state should keep in mind the interest of the community. Consent given by the state results in any type of pollution which may cause damage or injury to the public. Community can avail a remedy against state action. Remedies are available under various enactments. So the various remedies are as follows: self-help, civil remedies, criminal remedies, constitutional remedies, and remedies available under specific enactment which deals with environmental matters. Let us look into each remedy separately with certain examples or illustration. The first remedy is self-help. each individual person should create awareness about pollution, and we should participate in prevention, control and protection of environment. We must have concern towards environment. We should fight against every type of environmental pollution. We have to follow our ancient traditions, culture, customs and practices. All these things protects our nature, our natural environment. So one of the most important self-help is we should create awareness and we should participate in protection of our surroundings or our environment. The next remedy is civil remedy. This remedy is available as per law of torts. Law of torts is a law which is unwritten law and evolved mainly due to judicial pronouncements. Victim has to approach civil court in order to avail remedy in case of provisions available under law of torts. If any person violates any of the following provisions, victim can avail remedy by approaching a civil court under law of torts. The various provisions are under law of torts are nuisance, negligence, trespass, strict liability and absolute liability. Nuisance means unlawful interference with person's right or right available to the community. Again, nuisance is divided into two kinds, public nuisance and private nuisance. The second provision is negligence, duty to take care. Any person fail to perform his duty, it results into any kind of pollution, he is liable on the grounds of negligence. Trespass, if any person enters into others' field or trespasses and throws his waste, he is liable for trespass and remedies available under law of torts. Strict liability, it is old concept and this concept came from the case Ryland versus Fletcher. Strict liability also talks about strict liability consists of various exceptions. The new concept came in the MC Mehta case, that is absolute liability. Under absolute liability, no limitations or no restrictions are available and every person who causes environmental damage is liable absolutely. So any person can avail the provisions under law of torts and he can avail remedy with respect to any kind of environmental problems. Under law of torts, the victim or affected person can avail any one of the following remedies. The first remedy is injunction. The court can order restraining the commission, repetition or continuation of any wrongful act or any kind of environmental pollution. For example, if neighbor enters in your land or discharges his dirty water into premises which is causing environmental pollution, you can take action before the court and court can grant or award injunctions. The second remedy before civil court is damages or compensation. Depends upon the loss suffered by the victim or the person who affected, the court will award damages and damages are always reasonable damages. The third remedy is specific restitution. The victim is entitled to recover the loss or damage. Whatever loss which is caused, whatever damage caused, it has to be rectified and has to keep it in the same place. The next important remedy is criminal remedy. Environmental pollution provisions are available under criminal law. If you refer to criminal law, there are two important enactments which deals with criminal law, Indian Penal Code 1860 and Criminal Procedure Code 1973. IPC mainly deals with various definitions and punishment with respect to various kinds of environmental pollution. CRPC provides procedure to be followed in case of environmental matters. Under IPC, various provisions like adulteration of food, adulteration of drugs, adulteration of drinks. Section 272 to 276 deals with food, drink and drug if they are adulterated and they may cause damage or injury to public. In such situation, the person can approach criminal court and he can avail the remedy. The remedy available before the criminal court is imprisonment as well as fine against the wrongdoer or the person who is accused in that case. The next important provision is public nuisance. So any person causes any damage or injury which is common to the public, he is liable under IPC and the person is liable for punishment. The punishment is fine which may extend up to 200 rupees. Causing damage or injury to any animals, again there are separate provisions available under IPC 1860. Beside this, IPC also mainly deals with two important kinds of pollution, falling of water and air contamination. Any person fouls water or causes contamination of air is liable as per IPC under IPC made in the year 1860. So even though this is one of the very old enactment, this enactment itself consists of various provisions dealing with environmental protection and pollution, and it provides remedies in such situation. The next important law is Constitution. One of the most important enactment law of the land is Constitution. When Constitution came into picture in the year 1950, our Constitution does not consist of separate provisions which deals with environmental matters or environmental protection. The concept of environment was incorporated only in the year 1976 after the 42nd Constitutional Amendment Act, which deals with environmental aspects. The two most important articles are incorporated by this amendment, that is Article 48A and Part 3 of the Constitution, Directive Principles of State Policy. The next is Article 51AG, which deals with fundamental duties on citizens. Article 48A, Directive Principles of State Policy, imposes a duty on the state to protect and conserve our environment. Similarly, Article 51A Clause G imposes duty on every citizen to protect and conserve our environment. There are various other provisions under Constitution which deals with access to justice with respect to environmental matters. Those provisions are arbitrary state action, violation of fundamental rights, remedies in case of violation of fundamental rights, public interest litigation, and fundamental duties. There are other provisions available under Constitution with respect to environmental matters, arbitrary action against the state, fundamental rights, public interest litigation, and fundamental duties. Let us look into Part 3 of the Constitution, fundamental duties. There are three important articles. Those are Article 14, Article 19, and Article 21. Let us verify each article separately dealing with environmental concern or environmental matters. Article 14 of the Indian Constitution mainly deals with equality before law and equal protection of laws, and nothing was mentioned under this article earlier, but under this article judiciary interpreted and added a new concept known as arbitrary state action. When a state takes any action, if the state action is arbitrary and causes environmental pollution, a person can approach the judiciary and he can avail appropriate remedy. In one of the case, that is Bangalore Medical Trust versus Mudappa, in this case Bangalore Development Authority BDA allotted a land for the purpose of construction of a public park. After a few years, BDA converted the land and they want to transfer land for the purpose of construction of hospital. When the Mudappa filed a case before the court, and court held that compared to hospital, public park is more important in cities because people are living in apartments, they cannot get fresh air, and court held that public park is more important than construction of hospital. So this shows that state action, if it is arbitrarily, we can avail remedy under Article 14. The next article is Article 19. Under this article, we can refer to two important aspects, Article 19(1)A and Article 19(1)G. But these two articles are subjected to restrictions that can be imposed by the state under Article 19 Clause 2. Article 19(1)A mainly deals with right to know. Every person in India is having right to know what kind of industry government has given permission, is the industry are good or bad, and he can avail right to information as per Article 19(1)A. This article also deals with other aspect, freedom of speech and expression. The term speech and expression does not include to use speakers and amplifiers which may cause environmental damage due to noise pollution. Article 19(1)G mentions about every person having right to carry on his own trade, business, profession, occupation, etc. But if the trade is causing any kind of environmental damage, state can impose restrictions as per Article 19 Clause 2. The most important article is Article 21. This article mainly deals with right to life and personal liberty. The judiciary interpreted the term life and interpreted and they added many areas which comes or which deals with environment and environmental protection. So this article was interpreted and court held that right to live in pollution free water and air is one of the most important right under Article 21, that is right to live. Besides this, right to health is also incorporated under Article 21. Right to prohibition of smoking in public places is prohibited as per this article because it may cause damage to life of a person. So when a person violates any rights which are known as fundamental nature as per Part 3 of the Constitution. The victim can approach Supreme Court or High Court under Article 32 and 226 respectively to avail the remedies in case of violation of fundamental rights. The court can grant any remedy in the nature of writ even in case of environmental matters. The remedies are mainly mandamus, certiorari, quo warranto and prohibition. Mandamus means the court can inform the person to do or not to do a particular act. Certiorari and quo warranto issued by the court to the lower courts, informing the court to pass on the information and message to appropriate court. The next important remedy available in case of environment matter under Article 32 is public interest litigation. Earlier, the concept is locus standi. Affected person alone can approach the court to avail any remedy before the court. Judiciary interpreted this concept and they evolved a new concept which is known as public interest litigation. Public interest litigation is a tool in the hands of public spirited person. In case of environment matters, any person who is interested to protect the health of the public, he can approach the High Court or Supreme Court by way of public interest litigation and he can avail appropriate remedy to stop such kinds of pollution. Various issues came before the court to deal with public interest litigation and environment. The issues mainly deals with various concepts like public injury, public duty, public interest, social as well as collective rights of the public. So many cases came before the court by public interest litigation and court awarded and gave various remedies in such situation. So various environmental organizations also approach the court to avail the remedy in case of environmental matters. The most important organizations are MC Mehta is one of the most important person who is advocate and he mainly filed public litigation before the court to deal with environmental issues and is also known as Green Advocate. Besides MC Mehta, various organizations or associations like Velu Student Welfare Forum, Tarun Bharat Sangh is another association which went and filed a public litigation, Goa Foundation, Indian Council for Environmental Legal Action, Buffalo Traders Welfare Association, all these organizations approach the court in order to avail remedy with respect to environmental matters. So recently the court introduced new doctrines in order to deal with environmental matters. These doctrines are recognized and added at international level. Same doctrines were incorporated in India by the judiciary to prevent and control environmental pollution. The most important doctrines are polluter pay. Person is causing pollution, he has to pay the damage compensation to remove such pollution. And every person is starting any industry, project or any plan, he has to take precautionary principles. And court evolved one more important principle, that is public trust doctrine. This doctrine was evolved in the case MC Mehta versus Kamal Nath. In this case, the court held that state is the trustee, it is the duty of the trustee to protect the natural resources. State being a trustee, state has no right to use the resources for its own benefit. Other important doctrine is intergenerational equity principles. These principles say that every person in the society is having right to use natural resources, but we have no right to destroy or damage the resources. Whatever resources available to us, we have to use the resources and we have to preserve it for our future generations. The other important doctrine is the concept of sustainable development. The court held that development and environment both are important. For the sake of development, we have no right to cause damage to the environment. Need on the part of the government and the community to maintain a balance between the concept of environment and development. And after going through the various remedies and various provisions available under civil law, criminal law and constitution, let us look to special enactments which are made to deal with various kinds of environmental pollution. Out of these special enactments, I am going to refer to the most important 3 enactments which are the most important and useful for public. The first enactment is Water Enactment, second is Air Act and the third is EP Act of 1986. Each enactment deals with specific kinds of pollution. Water Act mainly deals with water prevention and control of pollution, which was made in the year 1974. The next enactment is Air Act. This act also mainly deals with prevention and control of air pollution, which was introduced in the year 1981. The most important and comprehensive enactment is EP Act of 1986. This act deals with all kinds of pollution. Pollution may be air pollution, water pollution, noise pollution, industrial pollution, hazardous waste, all these things comes under EP Act 1986. Water Act and Air Act only deals with water pollution as well as air pollution, but EP Act is a comprehensive enactment, deals with all kinds of pollution. Under this enactment, various rules, regulations and notifications are issued by the government to prevent and control certain kinds of pollution. For example, Coastal Regulation Zone Notification 1991 amended in the year 2011. And even we are having noise pollution regulation rules which are made under the EP Act of 1986. These enactments established separate authorities to prevent and control various kinds of pollution. The authorities are mainly Central Pollution Control Board and State Pollution Control Board at the state level. And there is one more board known as Joint Pollution Control Board, when one state and two states or one state and union territory join together and they want to start one single pollution control board, they can go for Joint Pollution Control Board. Authorities for these boards are mainly appointed by the state government at the state level and central board at the central level. These authorities are vested with various functions and powers. Authorities also got powers to control any kind of pollution by issuing orders. The orders are maybe in civil nature or criminal in nature. If you want to hire from this pollution control board, a person can approach civil court or criminal court in order to avail appropriate remedy which may be in civil nature or criminal nature. From this civil or criminal court, the person can prefer appeal to National Green Tribunal. From this National Green Tribunal, appeal can be preferred to Supreme Court. Pollution control board are having power to approach any court, it may be civil court or criminal court, as per the remedy they require in case of environmental matters. And one of the most important authority established is National Green Tribunal under the Environmental Protection Act of 1986. This tribunal was set up for effective and expeditious disposal of cases relating to environmental matters. This is a specialized tribunal, deals with environmental matters. This authority consists of experts dealing with environmental matters or environmental concern. Appeal from any order, decision made under Water Act, Air Act or EP Act can be preferred to National Green Tribunal. Appeals against the order of NGT can be preferred to Supreme Court. Appeal should be made within 90 days from the date of communication of the order. So from NGT, a person wants to prefer appeal, yes, the appeal has to be preferred before the court within 90 days. Access to speedy justice in environmental matters can be put before the tribunal. So what are the problems, what lacking in with respect to these enactments? Each and every enactment consists of loopholes that help industry as well as industrialists. So what are the enactments which you have seen, Water Act, Air Act and EP Act, they can stop number of loopholes. As a consequence, they are trying to benefit industry as well as industrialists. Many people commented EP Act as a paper decker, and even people inform that EP Act is like a poisonous snake without any venom. Authorities established under this act, they are not functioning properly in order to prevent and control environmental pollution. They need on our part to create awareness about pollution and its effects on public. Once public are aware about the effects of environment, they can try to prevent and they can try to approach appropriate court to avail appropriate remedy. Government should provide consent and permission without any bias or discrimination. Whenever government provides consent with bias, in such case, the victim or aggrieved party can approach the court under Article 14 or by of public intervention against their state action. We have to keep in mind environment being one of the most important concern for us. We have to always protect our environment, our surroundings as well as nature. Appointment of authorities by the central or state government is one of the drawbacks, and the act does not prescribe any qualifications except to the secretary under this act. And the next drawback with respect to Water Act and Air Act is collection of sample. Sample has to be collected in the presence of the owner or agent of the premises. They cannot collect the sample without this person. They have to collect the sample and they have to place the sample in separate containers, and it has to be sealed and signed by the person the officer in charge or person who entered the premises to collect sample, as well as agent or his owner of the premises. If the owner of the premises or agent is absent, the sample has to be collected and has to be kept and sealed in a container, and the officer has to give a written statement the absence of owner or agent at the time of collection of the sample. Then sample has to be sent to appropriate laboratory for testing, and the authority cannot send the sample to any other authority except the authority established under Water Act or Air Act. As a consequence, in majority of the cases, when the sample is sent to the laboratory established by state government does not have latest technology. As a consequence, they are not aware about what kind of pollution it is causing, and as a consequence, majority of the times it may help industry or industrialists. The other important lacuna under the Act is the authorities are having power to enter the premises in order to find out any kind of pollution. They can enter premises during working hours. Again, they say that working hours sometimes it may be morning or evening, and authorities also should be available in order to enter the premises to collect any kind of, to find out any kind of pollution or any kind of environmental damage in that industry. Every person or any person want to lodge a complaint with respect to any kind of environmental pollution, the person has to give a prior notice of 60 days to the authority, informing his intention to approach and to fight for environmental pollution. If the person fails to give notice of 60 days, the complaint is not maintainable before any court. The other important lacuna with respect to these enactments is authorities are not functioning properly to prevent, control and to conserve environmental pollution. Majority of the time, when the authorities are appointed by the government, maybe say state or center, they try to favor the action taken by state government or central government. Need to create awareness about environmental pollution and its effects and its causes. Many times or majority of the people in India, they are not aware about pollution and pollution effects. So they need to create awareness with respect to environmental pollution and effects of pollution. As a consequence, public may come forward and they may try to create awareness and they may try to prevent any kind of environmental pollution or damage in our society. Government should provide consent or permission without bias or without any discrimination. Whenever government provides any consent or permission to any industry plan or proposal, the aggrieved person or any person from the society can approach the court under Article 14 and he can challenge action of the government as violative of Article 14 because the state has taken action which is arbitrary and against the interest of the public. So after going through the presentation, till now we have gone through about the objectives with which this module is incorporated. We have seen about protection of environment during ancient times. So environment protection is not a new concept to us. We are from time to time we are trying to protect our nature as well as natural environment, and during ancient time it was known as Paryavaran, and even people started worshipping trees and forests was treated as Vriksha Devata as well as Vana Devata, and we protected environment. As a consequence, we are not there to destroy our nature, and till now even today also people are worshipping our plants. For example, Tulasi tree is worshipped by Hindus in every house every day. So this shows our concern for environment as well as environmental concern. So after going through ancient period, we discussed about the role of the state in protection of environment, and being a state being one of the most important authority to deal with environment, and duties imposed on the state not to cause damage to environmental issues. And besides that, even the court informed the state that they incorporate a new doctrine, that is public trust doctrine, and state being a trustee, state has no right to destroy the natural resources. In order to control the action of the state, we can you can avail any of the remedies like self-help. We have to protect ourselves, and we have seen about remedies available before civil court, that is under law of torts. We can avail remedy even before the criminal court, mainly under IPC as well as CRPC, and we have seen the most important remedies available under Indian Constitution like fundamental rights, part 3 of the Constitution, and part 4 of the Constitution, which impose the state to do lot of duties, that is directive principles of state policy. Duties are imposed on the public, that is the citizens, to deal with environmental matters, and even Constitution deals with remedies in case of violation of fundamental rights. After going through the Constitution and environmental matters, we have gone through various fundamental rights which deals with environmental matters. There we discuss about Article 14, which controls the state action which is arbitrary, Article 19, Article 21. These are two other important rights which are available under Part 3 of the Constitution. And after this we discuss about the new doctrines evolved by the judiciary to deal with environmental matters, that is public trust doctrine, precautionary principles, polluter pay, the concept of sustainable development, and we discuss about intergenerational equity principles. All these principles are evolved by the judiciary because of international fame and recognition. After going through new doctrines, we discuss about various special enactments which are enacted by the government from time to time to deal with various kinds of environmental pollution after 1972. So, those enactments are Water Act, Air Act and EP Act. Besides this enactment, various enactments were made by the Indian Parliament to deal or to protect forests, that is Indian Forest Act of 1927 as well as Forest Conservation Act of 1980. In order to protect animals, wearing a separate enactment, that is the Wildlife Protection Act of 1972. All these enactments are made in order to deal with various kinds of environmental pollution. And lastly, I discuss about role played by a separate tribunal established by the central government to deal with environment matter, which is the main object of this National Green Tribunal is to speed up the procedure and to give a remedy in case of environmental matters. And at the end, I discuss about loopholes available under various enactments which are dealing with environmental enactments. Thank you.